two court actions of the last month have invalidated work requirements in state Medicaid programs, and this was expected. The first came February 14th from the federal appellate court judge that struck CMS's, that's the Center for Medicare and Medicaid Services, approval of work requirements in Arkansas. And we have been following what's been going on in Arkansas for quite some time. This was the U.S. Court of Appeals for the D.C. Circuit. This had already made it through a federal district court and was up before a panel of judges at the D.C. Appellate Court. It was a unanimous decision upholding that federal district court ruling saying, no, you cannot have these work requirements in the state Medicaid program. We're going to show you a couple of the quotes in just a minute of what those judges elaborated on. But shortly after that appellate court ruled, we had another federal district court decision ruling on another state's work requirements in the Medicaid program. This time, that was coming out of the state of Michigan. This was U.S. District Judge Boasberg in Washington, D.C., on March 4th, giving a very short order saying that the work requirements that were coming out of the state of Michigan were invalid. Now, the name Judge Boasberg should sound familiar to you. He is the same district court judge that ruled against work requirements in the state of Arkansas originally, in the state of Kentucky, and in the state of New Hampshire. Judge Boasberg cited that appellate decision that had just happened in the middle of February when he ruled on his Michigan case. He then, because of that, invalidated those work requirements for the state of Michigan. He relied on some of the language that the appellate court had said, and I said we were going to come back to these quotes in just a second. That panel of judges in the appellate court said that the Centers for Medicare and Medicaid Services failed to show how work requirements could promote the primary objective of Medicaid, which they identified was to furnish medical assistance and provide access to medical care. They said very clearly, when you have work requirements standing in the way, you cannot accomplish that objective. The court also called the CMS approval of what was called the Arkansas Works program. They said it was arbitrary and capricious, and therefore approval was vacated. There was no reason, the court concluded, that work requirements should be part of the Medicaid program. Now, that appellate court decision technically impacts Arkansas directly and only Arkansas, but as you can already see in the state of Michigan, it's having an indirect effect and is informing decisions on other states' Medicaid programs. Now, if you were to look at the totality of states, 10 have asked the Centers for Medicare and Medicaid Services for approval of these Medicaid waivers that would allow for work. Utah is the only state with an active work requirement on the books right now. 2 states have suspended implementation of their work requirements, having addressed the idea that they want to wait and see how the rest of these litigation and these court actions play out. And there are more states that are awaiting federal approval or implementation for their own work requirements. Now, Michigan's Governor Whitmer called the district court decision in her state great news. As you can imagine, the Arkansas governor, Asa Hutchinson, wants the U.S. Supreme Court to review Arkansas's case. He thinks work requirements are a good idea in his state. Now, CMS has not indicated whether or not they're going to be the ones to appeal that Court of Appeals decision at this point. And in the meantime, Michigan is firing back, saying this would have been devastating to the health of our Medicaid population, where the Health and Human Services Director wrote in a court declaration, and we link to this in the description below, that it would have been something around 100,000 people of the 650,000 Medicaid beneficiaries in Michigan that could have lost their coverage at some point in 2020 had work requirements stayed on the books. This is not a small impact. This is a huge impact to the programs and therefore the health of the people in the state. So we link to a couple things in the description below so you can get a good sense of these 2 court actions and what they could mean for more states. First, that Court of Appeals decision, the Michigan order, and we said it's a very short order. Judge Boasberg essentially said, just look at what I've written the last 3 times I said this was a bad idea. And then finally, that Michigan Health and Human Services declaration, which goes into a little bit more of the health consequence of keeping work requirements on the book and how damaging it could be.